Welcome to all of you to this webinar on litigation before the UN Committee on the Rights of the Child in the field of immigration detention and alternatives to detention for migrant children. We're very pleased to see so many of you here. I'm Karolina Babicka, Senior Legal Advisor at the International Commission of Jurists, and I will moderate this event. The International Commission of Jurists is a global human rights organization, and we organized this event as part of an EU-funded project called RELEASE on strategically litigating immigration detention and alternatives to detention of children, which is a collaborative project among the ICJ and several national human rights organizations. And today we will be focusing on litigation to the UN Committee on the Rights of the Child. We're actually holding a series of webinars, and this is one of several. So we have already some weeks ago held a webinar on the Court of Justice of the EU, and we'll have at least one more webinar on the European Court for Human Rights later this year. The UN treaty bodies are bodies of independent experts, and not only oversee the implementation of the international treaties into national legal frameworks and practice, and provide also interpretative guidance on the treaties, but can also receive individual complaints and inquiries in specific cases. And as we are focusing today on the rights of migrant children in detention or at risk of detention, we will mainly be speaking about the UN Committee on the Rights of the Child that oversees the implementation of the UN Convention on the Rights of the Child. That convention has been nearly universally ratified, and it also started receiving individual complaints several years ago through its optional Protocol 3. And it has already developed some relevant and important case law. So it can be a very good tool to protect the rights of children across the world. And with our speakers today, we will explore the work of the Committee on the Rights of the Child and the various ways the lawyers and practitioners can use it, with a specific focus on the individual complaints procedure. So it is my pleasure to welcome our two speakers today. First of all, let me introduce Mikiko Otani, who is an ICJ Commissioner and an international human rights lawyer based in Tokyo with focus on women's and children's rights. She is a former member and chair of the UN Committee on the Rights of the Child, and currently also the president of Child Rights Connect, among other heads. And Mikiko will speak about the UN CRC and the ways how it can help protect the rights of children, especially when at risk of immigration detention. So thank you, Mikiko, for being here, and the floor is yours.
Thank you, Karolina, and for the kind introduction. And I will share my slide. So hold on 1 second. So can you see the slide?
Yeah. Yes,
okay.
We can see you. Thank you.
So thank you very much. So today I will talk about these key points. Firstly, introduction to the UN CRC Committee's mandate and working methods generally. And secondly, an overview of the general comments, concluding observations, and the individual communications, of course, focusing on the protection of the children in context of migration, and more specifically, in particular, the protection of the children against detention. And thirdly, practical tips for lawyers to submit an individual complaint. I was introduced as an ICJ Commissioner and also former member and the chair of the UN Committee. But at the same time, I have been practicing lawyer in Japan. So I'm trying to share some of the my observations, which might be useful practical tips from the point of view as a lawyer, as myself, I'm practicing lawyer, for lawyers who will use in individual complaint. So let's start with the introduction of the UN CRC. I will try to brief. However, I think it is very important to know firstly what the overall mandate and working methods of the committee. So if you are not so much familiar with the UN human rights mechanism, I would like to start by introducing UN CRC Committee as a UN human rights treaty body. So the UN human rights treaty bodies, sometimes abbreviated as HRTVs, are treaty-based monitoring bodies for core UN human rights treaties and their optional protocols, and part of the UN human rights mechanisms. And I will not go into the other mechanism, but just to mention others important UN human rights mechanisms include special procedures of the Human Rights Council, Universal Periodic Review, and Human Rights Council. And so the mandate of the UN human rights treaty bodies is to monitor implementation of the treaty obligations by the state parties who ratified or acceded the treaties. And so I mentioned the core UN human rights treaties, and I will come in the next slide what are the core UN human rights treaties. But there are some common mandates to all treaty bodies, which are review country reports, periodic reports, and individual communications. And some treaty bodies have authority to receive and open inquiry. And also, as Carolina mentioned, interpretive measures. The treaty bodies adopt general comments and general recommendations to clarify the treaty bodies, clarify the state parties' obligations under the treaty, or address some new issues or some particular issues under the treaty. And some treaty bodies has also the mandate of visit. So very importantly, the treaty bodies are composed of individual experts nominated and elected by state parties who serve in their personal capacity. So this is the just to show what are the core international human rights treaties and their monitoring bodies. So I highlighted Convention on the Rights of the Child and the Committee on the Rights of the Child as its monitoring body. Though I will not go into the discussion of other treaty bodies, however, it is also important to know that other treaty bodies may be also the opportunities to provide for the litigations and strategic litigation to bring up the issue of protection of the children in context of migration. So the UN CRC Committee mandate, again, review country reports and also individual communications and inquiry is also available under the optional protocol 3, or the formal title of this optional protocol 3 is the OPIC, optional protocol to the Convention on the Rights of the Child on the communication procedure. I mentioned the general comments and general recommendation. This is just a different way of using this particular document to provide interpretation or authoritative guidance to the state parties. In case of UNCRC committee, general comments are used for such documents. I also want to draw your attention to the scope of monitoring and individual communications and inquiry and the general comments. The committee, UNCRC committee, monitors actually not only the main Convention on the Rights of the Child adopted in 1989, which is now ratified by 196 state parties, but also 2 optional protocols, both were adopted in 2000. One is on sale of children, child prostitution and child pornography, which has 178 state parties, and the other is optional protocol on the involvement of children in armed conflict, which has 173 state parties. Because of those very broad mandate for monitoring, for the review and also individual communications and inquiry, the committee, CRC committee, has many backlogs actually for the country reviews. So according to the convention, all state parties are obliged to submit periodic country reports, state parties report for the review every 5 years. However, in reality, very often the state parties are delayed in submitting such periodic reports. And even after the committee receives the periodic reports, because of the insufficient capacity, the committees actually has many backlogs. Backlog meaning after receiving the reports from the state parties, waiting for the reviews by the committee. So now sometimes the reviewing cycle is around 8 years as average, but sometimes longer in case the state parties are delayed in submitting reports. The OPIC is relatively new among other treaty bodies which have the same mandate to receive individual communications. For the CRC committee, these new procedures, individual communications, they started in 2014. The OPIC itself was adopted in 2011, but it entered into force in 2014. At this time, it has 53 state parties. So the individual communications and inquiries are available for those state parties who ratify the OPIC. So now I'm coming to explain a little more about UN CRC committee membership. This is provided in Article 43 of the Convention on the Rights of the Child. So the committee is composed of 18 members, and as I said, the members are nominated by state parties and elected by state parties. Election takes place every other year, for election of half of the committee members, which means 9 members. So next election will come next year, 2026. There is no limitation to terms. One term is for 4 years, so the members can be denominated, can be re-elected without any limitation to terms. There is no rule for regional distribution. When I say regional, meaning according to the UN regional groups, there are 5 regional groups in the UN: the Africa, Asia Pacific, Latin America and Caribbeans, Eastern Europe, and Western Europe, and others. So it is actually up to the states parties who vote in the election. So I am showing the current composition of the 80 members of the committee. You will see how many members come from which regions. So the one point I'd like to highlight is the diverse background experts of high moral standing and recognized competence in the field covered by the convention. In my view, it is very important to understand the work of the UN CRC committee, particularly because all 18 members are not necessarily legal experts. I just put there, in case of CCPR, which is a human rights committee monitoring the International Covenant on Civil and Political Rights, there as a criteria for the membership, the legal expertise is emphasized. However, for the CRC committee, actually 18 members come from various backgrounds, of course, including law, but also such as the psychology and other, various educational background and a professional background, which makes the UN CRC Committee a very rich body to address all the children's issues. So the UN CRC Committee working methods, firstly, it's not permanently standing body somewhere. So the all 18 members are scattered all over the world and meet in Geneva, and 3 sessions per year in Geneva, 3 weeks for session, plus 1 pre-sessional working group when the committee members meet with the stakeholders. Concerning the individual communication work, around 4 to 7 decisions are taken on individual communication cases per session. However, this is the practice and what has happened until recently. But currently, the work of the UNCRC committee is heavily affected by UN liquidity crisis. For example, this year, only 2 sessions are held, and 1 pre-sessional working group was cancelled. So it also have impact on how many cases the individual communications may be delivered and also decided. I want to share some features of working methods. In my view, although UN CRC Committee is one of the UN Human Rights Treaty bodies, but I think it has some strong and, in my view, positive features, such as it engages with the civil society and UNICEF very proactively. As I mentioned, pre-sessional working group is dedicated for the CRC committees meeting with the stakeholders for country review. And also child participation is very much a feature of the working methods of the UN CRC committee. And I also want to mention its multilingual, multi-regional, and interdisciplinary approach. Multilingual meaning that the committee uses the 3 working languages, English, Spanish, and French. The multi-regional meaning that 18 members bring the expertise from each region, but also the committee very often looks into the practice and of the regional human rights bodies, which has the influence on the individual communication work. Interdisciplinary meaning, as I already mentioned, it's not the body composed of all lawyers. Actually, it has rich expertise in the 18 members. I think it is also very important when you look at the UNCRC committee for your work, because the regional human rights courts may be composed of the judges, of course, coming from the legal background, which is, of course, very important for interpretation and application of legal instrument. However, for these children's issues, I believe that it is very critical to have interdisciplinary perspectives to discuss the children's issues. Not only for the committee country reviews, but also for the individual communications. Finally, the UNCRC committee is very active and positive for cooperation and engagement with other human rights bodies, such as other UN treaty bodies, special procedures of the Human Rights Council and the regional human rights bodies. Again, this is a very important feature because although other treaty bodies do, but CRC committee looks at the practices and jurisprudence of regional human rights bodies. Now I'd like to come to the next point, which is an overview of the general comments, concluding observations, and individual communications, focusing on migrant children's issues, and more specifically, protection against detention. So first, this is the slide to show the development of UNCRC Committee's approach through its mandate. The General Comment number 6, adopted in 2005, was the General Comment on the treatment of unaccompanied and separated children outside their country of origin. In 2012, the committee organized the Day of General Discussion on the rights of all children in the context of international migration. The Day of General Discussion, I didn't mention earlier, this is for the similar purpose of General Comment. In case of General Comment, it is a long document, around 20 pages, and much more detailed and interpretation of the articles of the convention and clarifies state parties' obligations. Also, it includes a recommendation for the implementation of the treaty. Day of General Discussion is the one day, the platform in Geneva, where the state parties, UN agencies, academia, civil society, and also the children get together and discuss a certain topic. So some of the topics of the general discussion are selected later on as the theme for the General Comment. In this issue of the migrant children or children in the context of migration, the committee chose this topic for the Day of General Discussion in 2012. But as you will see in the letter, highlighted letters in red, the scope of the General Comment number 6 was expanded when the committee addressed this issue in DGD 2012. So in 2012, the DGD addressed the issue of rights of all children in the context of international migration, which will lead to the adoption of Joint General Comment 2022, 22 and 23 in 2017. This General Comment is actually joint General Comment of the CRC Committee and the Committee on Migrant Workers. So that is why the number of the General Comment is a little bit complicated, but I will just mention CRC's number 22 and 23. And this set of General Comments address very comprehensively the human rights of the children in the context of international migration. So you will see from the DGD 2012, the scope of the issue is actually expanded not only from the unaccompanied and separated children, but include the children who accompany the families. So scope is very broad, and also a scope of the children addressed is very broad, and also it addresses the general principles in 22, GC 22, and state obligations regarding the human rights of children in GC 23. And also, please look at the last part of the title of GC 23. It addresses the state parties in countries of origin, transit, and destination and return. So it is very broad, also about the scope of the state's obligations, not only the country of origin, not only the country of destination, but also starting from origin and even transit country, destination, of course. But if the children are returned to the origin, countries of origin, that countries obligations after the return is also addressed. So this general comments has a background, the migration crisis around that time in 2016, 2017, and the UN Global Compact on Migration was adopted in 2018. So this general comments was adopted at the same time. The feature of this general comment, of course, in the context of global migrant crisis and UN work to develop global compact on migration, but the CRC and CMW's joint comment has the strong feature to integrate child rights perspective, child rights approach into the immigration policies. So there, the special vulnerability and the needs of the children are highlighted. The children, even if the children are 15, 16, 17, those children are sometimes treated almost like adults, but the general comments emphasize that children are children and should be treated as children because of the special entitlement under the Convention on the Rights of the Child. Because children under 18 should be treated as children, the age matters a lot. So the general comments address the issue of age determination, but also even after the children reach 18, the support for those children who are in the context of international migration should be supported. Non-discrimination, best interest of the child, right to be heard, right to life, survival and development, non-refoulement, those principles were discussed in GC 22. In GC 23, a broad issue of human rights of children are discussed. And the development of CRC Committee's approach to the issues of migrant children through its mandate continued after the adoption of these general comments, joint general comments. In 2019, UN Global Study on Children's Deprived of Liberty report was submitted to the General Assembly. And the migration-related detention was identified as one of 6 situations which will cause the deprivation of liberty of children. In this UN Global Study, the CRC Committee was engaged in the process very actively in the drafting, and also after the report to the General Assembly, CRC Committee is continuing to engage in the follow-up. The concluding observations adopted under reporting procedures are also source of development of CRC Committee's approach to the migrant children's issues. I will share more specifically about what kind of recommendations the committee makes later on. And of course, the jurisprudence of decisions on individual communications procedure under OPIC. Inquiry procedure under the OPIC, so far, according to the publicized reports, there is no report published under the OPIC inquiry, which addresses the children, migrant children. However, there is a possibility for this inquiry procedures to be used for the protection of children in the migration context, in particular detention issue. So they look at more closely about the protection of children against detention in GC 23, right to liberty. I copied all the relevant paragraphs in the slides for your reference, but I just highlighted a very strong statement of the committee concerning the detention issue. Every child at all times has a fundamental right to liberty and freedom from immigration detention. The detention of any child because of their or their parents' migration status constitutes as child rights violation and contravenes the principle of the best interest of the child. Children should never be detained for reasons related to their or their parents' migration status. Paragraph 6 says immigration detention is understood by the committee as any settings in which a child is deprived of his or her liberty for reasons related to his, her, or his, her parents' migration status, regardless of the name and reason given to the action of depriving a child of his or her liberty, or the name of the facility or location where the child is deprived of liberty. So you will see the definition of immigration detentions by the committee in this general comment. So, sorry. So I will skip some paragraph, but I also want to highlight paragraph 8, which says children should not be deprived of their liberty, and that detention cannot be justified solely on the basis of their child being unaccompanied or separated, or on their migratory or resident status or lack thereof. And paragraph 9 says the committee emphasizes the harm inherent in any deprivation of liberty and the negative impact that immigration detention can have on children's physical and mental health and on their development, even when they are detained for a short period of time or with their families. Paragraph 10 says the possibility of detaining children as a measure of last resort, which this is actually the language under the Article 37B of the Convention of the Rights of the Child, which may apply in other contexts such as juvenile criminal justice, is not applicable in immigration procedures as it would conflict with the principle of the best interest of the child and the right to development. Paragraph 11 says the states should adopt solutions through legislation, policy, and practices that allow children to remain with their family members and or guardians in non-custodial, community-based contexts while their immigration status is being resolved and the child's best interests are assessed as well as before return. Because the states very often argue that detention is necessary when the immigration case is pending in the courts and the courts conduct the assessment of child best interest. And also detention is sometimes necessary just before return as procedure. But the committee's position is very clear. Even those cases, the detention is not allowed. And also the committee said when children are accompanied, the need to keep the family together is not a valid reason to justify the deprivation of liberty of a child. Because again, and this is also often the justification used by the states, children shouldn't be separated from the families in the Convention on the Rights of the Child. So to put the children together with the families, the children need to be detained. But the committee said when the child's best interests require keeping the family together, the imperative requirement not to deprive the child of liberty extends to the child's parents and requires the authorities to choose non-custodial solution for the entire family. So you will see the very strong position of the committee. So I will skip some of the slides, but you can see those all the relevant paragraphs in GC23. So I recommend you actually to look at the general comment 23 comprehensively, because today I am focusing on the protection of children against detention, but GC23 covers all the relevant human rights of the children in the context of migration, the education, health, non-separation from the family, access to justice, and so those are also very important human rights of the children in the context of migration. But now I move to the concluding observations. I put one example, the committee's concluding observation to Czechia, Czech Republic in 2012. So the committee always addressed the issue of children in situation of migration in the name of the heading, Children in Situation of Migration, sometimes migrant children, asylum seekers, and refugee children all together under the special protection measures. So this is just one example, but you will see the committee firstly address the concerns and then provide the specific recommendations. The committees currently identify maximum 6 areas which committee believes thinks that third parties needs to take urgent measures. For those specific maximum 6 issues, the committee firstly put the concerns in a detail and then provide the recommendations. So in case of these concluding observations to Czech Republic, the committee identified the migrant children issues as one of such 6 areas which requires urgent actions. So I will not read out, but you will see that the committee is using the general comment 22 and 23 as a basis for specific recommendation to the state parties. Now I want to introduce the database of concluding observations, because I just used one example to Czech Republic, but for your advocacy work or litigation work, it will be very useful for you to look at other concluding observations concerning the migrant children's issues. So this is the web page of Universal Human Rights Index, which is available from the UN CRC Committee's website. And if you go to this Universal Human Rights Index and start your search, you will see this page. And you can use this page to narrow down your search. For mechanism, you can choose CRC, and I would recommend just type the keywords such as migrant children here, and then you will see the 430 recommendations and observations from 134 documents. So now you will see here on the right bottom side. So this is the shows the concluding observations UN document number. So the most recent latest observations appear first. So you will go down to see the most recent recommendation to the older one. So this is a very important and useful tool for your work. Now I come to the individual communications, and I understand that we will hear more about this case, but I want to highlight some of the very key important findings of the committee on this issue, EHAO versus Belgium. Case number is 55/2018. In this case, the committee specifically addressed the issue of detention of the child. The committee's jurisprudence under the OPIC on the issue of migrant children include other issues such as the age determination issue or violence against the children or the access to justice or right to be heard. But this particular case is exactly about the detention of the child. So that is why I introduced this case. So the relevant paragraph of the committee's findings starts from paragraph 13.9, and I highlighted very key part of these findings. The committee said, referring Joint General Comment 23, the detention of the child on the basis of the migration status of his or her parents constitute a child rights violation and contravenes the principle of the best interest of the child, given the harm inherent in any deprivation of liberty and the negative impact that immigration detention can have on children's physical and mental health and on their development, and that the possibility of detaining children as a measure of last resort should not apply in immigration proceedings. I want to highlight the underlined part because the committee mentioned the concluding observations to the Belgium, which was adopted in 2019. So you will see that country reviews and the individual communications and the general comments, how those three work of the committee under its monitoring mandate interact each other, and how the committee is using the general comments in the communication procedure in its finding, and also the using the concluding observations to this particular country. You can read this case later, but I want to highlight paragraph 13.12. The committee said, although the place of detention was called a family home, it was still in a closed detention center. You remember that committee defined immigration detention in the General Comment 23. So this is the committee's position already was clarified in General Comment 23. And also committee said depriving children of liberty on the basis of their immigration status or that of their parents is generally disproportionate and therefore arbitrary within the meaning of Article 37B of the Convention. I highlighted one part of paragraph 13.13. The committee said the author's exercise of her right, author is actually the mother of the children, so the children's mother's exercise of her right to judicial review cannot justify the detention of the children. It is very important because the state parties argued that mother continued to use the judicial process to fight against the deportation, and because of that, the children needed to be detained in this period of judicial review. But the committee denied such argument. Finally, also the committee said the state parties considered no alternative to confining the children, and there is no evidence that the national authorities considered maintaining these living arrangements or applying any other appropriate alternatives, or that the best interest assessment was carried out in connection with the decisions to detain the children or to extend their detention. By failing to consider a possible alternative to the detention of the children, the state party did not duly take their best interest into account as a primary consideration, either when it detained them or when it extended their detention. So the committee concluded the detention of the children constituted the violation of Article 37 as an arbitrary detention, let alone and in conjunction with Article 3, which is the article for the best interest of the child principle. So in the remaining some minutes, I'd like to share some of the practical tips for lawyers to submit an individual complaint. Some points for consideration. Firstly, who can bring the case, which is provided in Article 5. The children and alleged victims, child victims can bring the cases. The other adults who can also bring the case on behalf of the children, such as the parents. It is very important to highlight where the communication is submitted on behalf of an individual or group of individuals. This shall be with their consent, unless the author can justify acting on their behalf without such consent. So firstly, so group action, collective action is not possible. However, the number of alleged victims can bring the case together, and the individuals or group of, so the communication can be also submitted with the consent of the alleged child victims, or if justify acting on their behalf, then the submission without the consent is also possible. It is very important to mention that which rights violation can be claimed under any rights under the convention or two optional protocols. However, only the rights of the children can be claimed under the OPIC. Admissibility criteria, Article 7, should be examined very carefully because the admissibility criteria is often common for many such procedures. However, in the case of OPIC, for example, a 1 year time limit for the submission of the communication after the exhaustion of domestic remedies is provided. Interim measures, third-party interventions are possible, and I just want to mention one point: representation by lawyers. So when the submissions are represented by the lawyers, which may give the impression to the committee that, of course, the authors are children themselves or the parents on behalf of the children. However, so they should be very much aware of the procedure because they are represented by lawyers. So this is, I think, I'd like to bring attention because the lawyers, of course, the lawyers who represented the cases in the domestic procedures are familiar with the case and familiar with the domestic legislation. However, the lawyers who represented the case in the domestic, procedures are not necessarily familiar with the UN procedures. So I think as a lawyers, we should be very careful to study the procedures of the OPIC and rules of procedures, working methods, and jurisprudence, and the committee's approach. And so that's why I highlighted that know the CRC approach and jurisprudence better is very important. oral hearing is also possible, friendly settlement is possible. And I also want to highlight the need to explore other procedures if your country is not a party to the OPIC. Don't give up using the individual communications because the individual communications are available under the other UN human rights treaties bodies. If your country is the state party to other treaties which provide individual communications. So here is the source of information of OPIC rules of procedures and working methods, but more guidelines are available here on interim measures, third-party interventions, and individual complaints from and guidance node. So because I am already running up of my time, the remaining slides just to show how you can search the jurisprudence. And here is individual communication jurisprudence database, and just showing how you can use this database search. So this is my presentation, and I'm happy to receive any questions later on. Thank you very much.
Thank you. Thank you so much, Mikiko, for providing this really detailed overview of the committee's work. And especially thank you for going through the committee's general comments and concluding observations regarding immigration detention of children, also for the practical tips for lawyers. And we'll actually be able to dive even more into the details of submission of individual complaints to the CRC with our next speaker. I think we should hopefully have at least 10-15 minutes for questions at the end of the webinar today. And if you already have questions in the meantime, please don't hesitate. You can also put them in the chat already. So our next speaker is Hind Riad, who is a Belgian lawyer practicing in the field of asylum law in a law firm called Progress Lawyers, and she'll speak about an individual complaint that they have brought to the UNCRC on behalf of children who were detained with their family. It's the case that Mikiko has actually just mentioned, while Hind will give us a full background of the case and we'll talk about their experience when bringing the case. So Hind, I don't know if you are with us.
Yes. Can you hear me well?
We can hear you. I'm not sure we can see you, or maybe it's me. Yeah, we can see you. Perfect. And you can share your presentation as well.
Perfect. Okay. Hi, everyone. Thank you for the invitation, Carolina and the rest of the team. And also thank you, Mikiko. It was a very interesting explanation of the CRC. And so indeed, I will talk more in detail about the case that was just mentioned, the Communication 55 of 2018. So let me just try to share with you guys the presentation. I hope. Carolina, can you just tell me if it's okay? Can you see it well?
Yeah.
Okay,
it's up.
Perfect.
We can see that.
Okay. So I don't know if we will have time to discuss everything. Maybe I was a bit too eager to talk about everything. But so as was said before, the case concerns the detention of a family of very young children in Belgium in 2018. But I will talk very briefly about the context before 2018 in Belgium. That new law that made it possible to detain the family 2018, the procedures that we launched before in Belgium, and then at the UNCRC. What happened? You already know it. It was a positive decision from the UNCRC, but I will give some more details and then maybe tell you more about the outcome of the communication. So prior to 2018, I don't know if there are a lot of people practicing in Belgium, but we were unfortunately already detaining children, sometimes alone, and most of the time with their parents. So because of that, we already had been condemned by the European Court of Justice. Of Human Rights, sorry. Prior to 2018, there was a very famous case, I think the case Tabita, in 2006. That was a very young girl who was separated from her mother and was kept in detention here. And we were also condemned, I mean, Belgium government, which is not me, of course, but Belgium was condemned also in 2010. That was more concerning a whole family who was detained also. So those two condemnations made it really, I think, important inside the Belgian politics, and of course the Belgian NGOs and lawyers were very aware that we had this problem, and there were a lot of campaigns going on already then, and it led to the fact that we stopped in Belgium detaining children in migration context from approximately 2008. There were a few cases still, but the general politics was to not detain children, but unfortunately that was not for so long. The context is a bit particular because actually in 2011 was a new law who was voted that was kind of giving a positive injunction to the decision of the European courts. So we were respecting the European Court by saying that we would not detain children anymore. That was really the title of this law of 2011. But unfortunately, I don't know if this was politically very thinking of, or it just happened. They actually put in the law also a lot of options where you could actually detain children. So the principle was set out. We would not detain children anymore in migration context, but except if it happens in places adapted to the needs of the children and as a last resort measure, which was actually kind of, respecting the jurisprudence from the European Court, which is still the case for the moment. So this was voted in 2011, and then there was like not really giving it any consequences. It was set aside. NGOs were actually also quite happy about the fact that in principle we would not detain children anymore. But then in 2016 the government decided to start a construction of a new detention center. As was said before, it was called family unit, but and I will come to it, it was actually just a new detention center. It was built just next to the airport, the Brussels airport, which is our biggest airport in country. And I will give you a few pictures to see how it looks. And in the law, it was also, by then it wasn't not mentioned in 2011 how long you could detain, but then there was like a new executive order where they mentioned that the detention would be possible for maximum 4 weeks, and it was again emphasized that it would be as last resort measure, as also, as I said, explained by the European Court of Human Rights. So I tried to find a few pictures of those family units, as they called it. Yeah, as you could see, and I think it depends on in which country you live, but it looks quite okay. If we could say it's okay. It's still a detention center, but they try, like you see, there is a little playground. It was quite new, so it looked quite clean, for example, etc. What of course is not really, what you cannot see is, you can see in the back there is nothing. It's completely alone. The big building you see after the playground is actually the detention center for adults, which is still there also. And what you cannot hear or see is the fact that it's actually really built next to a runway from the airport, but like really, really close. I went there to meet, for example, the family we will talk about today, and the noise was really horrible. So the choice to build it there is really, really particular. I imagine it was set there to make it like easier for the deportation, but to put children there is really like a very particular choice, I think we can say. So that was 2016, and as I said, it was quite silent. Like we knew there was something going on construction, but we really didn't know, like, will they arrest families again? As I said, since the condemnations from the European Court, there was really like this feeling amongst lawyers, NGOs, that okay, you know, family with children are safe from detention. But then we heard rumors that they would set out, they would try again to detain a family, and unfortunately that's what happened in the middle of the summer. And that's of course not also just by, I mean, that's really carefully picked up by the government. I don't know for percent in other countries, but in Belgium, as lawyers in dealing with migrants, we know that the summers are really, really, really busy, because that's when actually the alien office here arrests a lot of people and try to deport them, because they know that a lot of lawyers, for example, are on vacation. So that's what they did also with the family B. So the family, so for you to know, it was actually composed of a young mother with 4 very young children. As I said, it was 2008. The child was really a baby, born in 2017. The oldest only 6 years. She was alone because her husband had been detained in jail for criminal offenses, unfortunately. But it was a family who was there for a very long time. They were there since 2010, and all of the children, the 4 of them, were born in Belgium. The situation was quite particular because they were of Roma origin, and they were of Serbian Kosovo ascendants. So the nationality was really a big issue. It was not clear, especially for the mother, but also for the father actually, what their clear nationality was. So they, in the past, they had been tried to obtain some kind of a residency permit, but unfortunately they did not succeed. And since the children were born, there was no procedure intended. It's not so important to know, but it wasn't actually the lawyer of this family prior to the detention. It's only when we got detained that we were in contact with them and we became a lawyer. So I wasn't everything, especially at the moment of the arrestation, everything went very quickly, but they were in an illegal situation, as we say. And the situation, I think, especially, you know, when you look back, we all have the feeling at my firm and all the organization we worked with on the case, that this case was really like picked out because of the fact that she was very vulnerable. The fact that the father was in jail was, of course, for the public interest also, you know, more of a reason that could justify kind of a deportation. And the Roma origin, like in a lot of countries, also in Belgium, there are really very negative feelings and discrimination against Roma people. So that's a bit of the setup of the case. And as I said, I think because of this, it was set out in the summer, and at that time in 2018, it was the first time that we had a very, not the first time, but one of the most right-wing government we had. It's unfortunately now even worse, but at that time it was only beginning. And the minister who was responsible for migration, it was the first time for us. I know other countries, from lawyers, I heard that they were kind of also used to really instrumentalized by this. He really had like a political campaign. He actually got very popular, unfortunately, based on the case, because he really was very proud of the fact that he arrested his family. So unfortunately, it's all in Dutch, but he tweeted really a lot of texts like every day, how proud he was that he arrested this family, that he was going to do everything to get them deported, that it was, a new age coming in Belgium, so we could deport more easily persons who were here illegal. And unfortunately, we got kind of stuck in the political game as well, because every procedure that we intended to try to, in the first time, to get some, residency for this family, and also to get them released from the detention center, was really used against us. And as was said before, we intended a lot of procedures, as I said, because actually yeah, nothing was tried since children were born, and we really wanted to focus on the best interest of the child, and that's also a reason why we, after that, lodged a complaint at the UNCRC. For us, we really tried to explain to judges that the best interest of the child had never been taken into account, because actually there was no procedure that was ever started for the children. So, for example, one of the first things we did is to intend asylum procedure in name of the children. So not for the mother. The mother was, of course, there as a representative, but it was really the question whether the children would be safe in case of returning to Serbia, a country they had never known before. So the asylum was the first thing. And then based on the asylum, we actually said, since they are asylum seekers, it's the first asylum case, those children should be legal. And they were legal. They received what we called an annex, so they had a temporary residency permit. So we actually hope that once the asylum would be filled in, they would actually be released, because you cannot detain persons who are legal. Unfortunately, surprisingly, we were not followed by the judges on this point, because they all argued. That's also what Mikiko said. It all argued that no, the mother is doing this. So the fact that the mother is using judicial procedures should not be positive for her children, because she's still illegal, which is of course the other way around. The children were legal, so actually they would have been, they should have been released, and you cannot separate the mother from the children, so everybody should have been released. But so unfortunately, we did a lot of procedures there. We went to different judges, because there are different possibilities for that in Belgium, and all of them really refused to follow us. While, to be honest, it's really a very basic argument to say from the moment that you are legal, you shouldn't be in detention. After that, we tried more the angle of the detention itself. So by saying it's not a last resort measure, for example, because it would have been possible to have alternatives, because the children, they were living with the mother, but together also with the grandmother, and the grandmother had some more of a stable situation. So we also explained to judges they should have at least let the children with the grandmother and see there, with controls like you could ask the mother to come every week to see if she's still there. That would have been a possibility. So the alternative to detention were not considered at all. But unfortunately, also there we were not followed by judges. Also have to, just for you to know, guys, detention of migration in migration context is really particular in Belgium, because we don't have a specific judge to go to. So you have to go to the judge who's actually also competent for criminal cases. And unfortunately, those judges are not aware at all of the legislation that's specific for migrants who are detained. So we were surprised that we didn't win from the beginning, to be honest, but at the same time, that's really like a systematic and structural problem we have in Belgium, and that's still not resolved. The fact that you go to this criminal judge who's actually not aware at all of migration law and asylum, etc. These are all concepts that they are unfortunately really not aware of. So when we saw that this was not possible, we really focused on the detention conditions. And that is also something I would all advise, of course, is we called for doctors, for pediatricians also to go to see the children, and we asked them to really objectify the situation. Me and a few of my colleagues, we already had seen the children and the mother a few times to go to visit them in the center, and we also noticed that they were not well. You know, there was this playground, but if you want to go outside, because of the noise, you had to put like this on, because the noise was so horrible. So it was really not possible to actually play outside, although it was summer. It was really hot inside. That was also something that they didn't take into account. And the detention, really, as you could all imagine, was harming the family. The mother, who was quite young, was completely alone. She was really shocked. She was still breastfeeding at that moment, for example, and because of the shock of the stress, she just couldn't do it anymore. And for a mother who was breastfeeding, I think we can all imagine how difficult it is, you know, to stop from one moment to another with this breastfeeding. The child also couldn't eat for a while, because was not used to other milk. So there were a lot of very bad situations, and that was all put out in reports, in medical reports that we used also there to convince judges that this family had to be set free and that the detention was really harming them, especially, as I said, because of the noise, for example, very near to this runway of the airport. And then maybe the final drop for us to go to the UNCRC was the fact that they didn't even respect the maximum detention time. So as I said, this law didn't talk about the detention time, but after that there was like a government measure who set out that the detention should be maximum 2 weeks and it can be prolonged to maximum 4 weeks. Okay, but the 4 weeks was the absolutely maximum. And in this case, we were 4 weeks further, and they were still they were set free at the moment, but then they got arrested again, and so the 4 weeks were not respected at all. And although we went to judges also for that, we couldn't convince any national judge that the family should be set free. So that's why at the end we decided to lodge a complaint, an individual communication, as they say it, with the UNCRC. We first asked for the interim measures, and I will talk about this right away. And then we continued with the individual communication. Sorry. So maybe for the lawyers, but also for the NGOs members who are here present, why did we go to the UNCRC and not to the European Court of Human Rights? That was for us also really from the beginning of this case, because we did know that it would be an important case. The issue, where should we go? Should we go to the European Court or not? So we kind of, now it's very clear. Of course, at that moment, it wasn't that clear in our heads, of course, but we did have some criteria or some differences that we set out. So for us, it was clear that the other cases before the European courts were really similar to our case. For example, there was this case in France from 2016, also minors who were detained with their family, with their parents, near an airport. And because of the airport noise, the European court, one of the reasons, the European Court condemned France. So we were thinking that maybe we could use this case law also to try for Belgium. Now, the differences with this case, and that were not in our favor, was the fact that the detention before the law, because in practical it was not the case, but in our law it was really set out that detention would be a last resort, that it would be adapted to the needs of children and the family. So that was different from the case law in France, for example, where the law didn't provide this. And we really, and that's what kind of inside information that we received from the European Court, is that you really have to look also at the facts. So what was negative and different from the France case is the fact that it was a Roma family that were illegal for quite a long time in Belgium, and that the father was in jail. So the factual context was really much more negative than it was in the case against France. And also the fact that there had been some asylum requests were rejected, that was also something negative that was not in our favor. So the choice then to go to the CRC and the arguments that were in favor, there were a few. So the first one was also, and that's something I think very important also for other lawyers, is that we received considerable help from the Belgium Ombudsman for Children's Rights and also from the Organization Defense for Children International. And by help, I really mean, thinking strategically. The idea of the UNCRC was also really set out together with the Belgium Ombudsman, but also help really to understand maybe a bit better how the UNCRC works, for example, because it's not a tool at my office, for example, that we used. Before that, I think it was actually the first time. So we went to see, of course, to look at the general comments from the UNCRC, as Mikiko also mentioned. that were just much better than the cases from the European Court, because the European Court is really also always making that proportionate examination whether the detention is okay in that context. The UNCRC is very clear about the fact, and it was again confirmed in this case, that migration based on the administrative status of the parents is actually always a kind of an unlawful detention. That was for us, I think, the main reason to go to the UNCRC. And then specifically concerning Belgium, we actually had, our government had ratified the additional protocol for individual communication. So that meant for us that it was legally binding and that Belgium should follow the decisions coming from the UNCRC. Another thing also maybe important, together with the fact that detention should never happen for children in migration context, was the fact that the best interest of the child assessment is really central in the general comments and for the UNCRC, which you can now much more also find in jurisprudence from the European Court of Human Rights, but it's really much more emphasized in the UNCRC, and that's also what we wanted to use in our case, and which we actually had used with the national judges, but were not followed up on. Maybe something also important, that depends maybe on the country, but for Belgium, we do have this good international reputation most of the time about how we treat about human rights, but also how we treat, migrants and refugees. So I think that was also for us something to use, that Belgium, if they would not follow up the decision from the UNCRC, it would be kind of negative reputation for them. The unknown factors on which we didn't have much experience or much information was, of course, as I said, the question whether Belgium would react positively or not. We thought it would be legally binding, so for us, we hope that Belgium would react positively. And also one thing we didn't know and where we didn't have any experience is how long it would take. So the interim measures, we had never tried this before at my office, for example, so we didn't really have any idea. So what happened concretely? So we sent a request for interim measures on the 17th of September 2018. And so just to give you a quick look, the interim measures really focus on the detention is harming the children, as I said, based on the reports we had from doctors, from the pediatricians. So we said it would be a violation of the it would be an inhuman or degrading treatment for the children. Best interest of the children had not been taken into account, so we ask you to compel Belgium to release the family and also to stop the deportation to Serbia. So the UNCRC follow up and follow us on those demands, and the answer came to us on the 25th of September. Which is apparently, now that I know this, actually quite soon for the UNCRC, because as was explained before, they don't have a permanent working, they have only a few sessions a year, maybe even once a year now. So this lapse of time is actually quite quick. For us, it was not quick enough, of course, but I think it's quite reasonable. And the demand from the UNCRC was that the family should be released immediately, and that the expulsion to Serbia had to be suspended. So, of course, the same day we sent this decision, from the moment I received it, I sent it to the alien office, and they responded very, very quick. I think at least maybe less than an hour. I received a mail from the director of the alien office that they would not respect this decision because communications from UNCRC, even in interim measures, were not legally binding, so we would not release the family. Of course, we were extremely disappointed. As I told you, it was already a political game, so at that time also, all the journalists were calling, everybody was asking for comments. The minister was also reacting that he follow up the legal advice of the alien office that it was not legally binding. So we immediately also communicated to the UNCRC explaining that, okay, thank you for the interim measure, but unfortunately Belgium is refusing. We didn't receive any response to that, not immediately. I think after a while they did say that they sent like a letter again to emphasize they should respond to the request, but unfortunately, it's not a surprise, I think, but they actually just didn't care about the decision. So what after this injunction, there was really a political discussion in the government. A lot of academic experts were also heard in the media. We also really reached out to a lot of professors, to try to emphasize that since Belgium had ratified the additional protocol, they should respect the decision and the injunction from the UNCRC. But unfortunately, in a few weeks, actually, everything was going very badly, although we had won, if we could say it like that. So they didn't release the family, and the asylum request that we had filled in for the children, in name of the children, had been definitely rejected. So even in appeal, we had lost. The judges didn't find any problem. They stated that the children could go safely to Serbia, that the deportation was possible. So we had no solution at all for this family, because you could say that the detention is illegal, but as long as the family has no residency, it's really difficult to be able to win on them to be released. And in a few weeks, as I said, everything was handled. So on 25 of September, UNCRC was saying that they should release the family. And like I think 2 weeks later, the judges gave them positive injunction for this family to be deported. And that's unfortunately what happened. So it was I think you can all imagine a very, very big failure for us. It felt very bad. And we also felt very bad for this family the first time. Because it was, as I said, a young mother with 4 very, very small children who never set foot in Serbia. Family there, the mother could speak the language, but still she didn't have any network or whatever. So we were really afraid of what would happen. And at the end, she did find in a refugee camp for Roma, because that's where she actually ended up, since she didn't have any family. She ended in this refugee camp, and we still had contact for a few years. I must say that last year I don't have any contact anymore, but for a few years we tried to help her by put in contact with for example, the ombudsman, but also with other organizations. There were even some journalists from Belgium who went to see her in that refugee camp to, to follow up on the story, to really explain also to the Belgium politics what kind of consequences their decision had. So it still is like a very big case politically, I would say, but also yeah, thanks to the UNCRC, it became also a very interesting case, I think, for detention. So just for you to know, as I said, after the family, we follow up this family, but they arrested 3 other families. So in total, it was approximately 20 persons who were arrested and put in this family unit and also expelled from the territory. We didn't follow up on those families. I must say that, mentally, it was just personally for me not possible anymore to follow up again on a new case. I was really exhausted, and yeah, you don't feel very good, of course, when your clients get deported in that kind of a situation. But we heard from other lawyers that most of those families really accepted to go back. So there was no struggle anymore. And at the end, it took a while, but like in April 2019, there was another procedure also that was set out against the law itself. So the law was attacked in front of our highest administrative court, which is the Council of State. And the law who made it possible to detain the families was actually suspended based on the possible violation of Article 3 of the European Convention of Human Rights. So as I said, based on the noise, but also the air pollution near the runway, because the family unit was actually built near the airport, but actually it was just in the airport. Particular is that the law was eventually not annulled, so we lost after that. It was not my case, but the NGOs lost for the annulation, but based on the suspension, after that, there were no families anymore detained in Belgium. The communication itself, and I think I'm running out of time, I don't know, but the communication itself, it was also kind of discussed, I think, by Mikiko, but basically in 2022 then in December, we received the final communication from the UNCRC before that, we had, we as party and then the Belgian state had to exchange observations on the case. And so the final decision came in December. It was also a condemnation of Belgium based on the fact that it was an unlawful detention, that no alternatives were considered for detention, and the interest of the child was not sufficient. As I said, for example, you could have been living with the was not considered at any point. And already
And I'm afraid we lost you for a bit. Let's see if Hind can come back. Yeah, we realized there's a slight problem with the internet connection.
Is it better? Can you hear me again?
Yeah, now we can hear you.
Okay, I'm really sorry.
No worries. And perhaps if you can try to wrap up within 1 or 2 minutes. Thank you.
Sure, I'm at the end. And can you see the presentation again?
We don't see that now, or I don't. At least I don't see that.
No?
I don't see.
No, but you can hear me.
We can hear you. Yeah.
Okay, I'll just continue. But actually, it's my last 2 slides. So what happened? No, maybe concerning this communication, I could also invite you all to read a joint opinion from the 2 judges who were partially concurring. Very interesting because they did consider that the deportation to Serbia was also a violation of non-refoulement, which was not followed by the UNCRC itself, though they only estimated that the detention was not okay. But so those 2 judges, they mentioned also that non-refoulement had been violated. So basically, that's the end of the presentation. It's just that, so after the injunction from the UNCRC and after the decision from the Conseil d'État for us in 2019, there was no children detained in Belgium anymore. I think that the decision from the UNCRC in 2022 also was a very big importance, but to put out the context, there was also really a very good and impressive campaign work from NGOs, from the Belgium Ombudsman, from Defense International, for example, also to really, just definitely put a stop to detaining children based on the migration status. And I think thanks to all of those elements, we kind of won because the law finally changed. It was only a year ago, in May 2024, they finally changed the law. It was a new government. And there was really like this prohibition to detain children. There are a few exceptions again, but it's really much more limited. And in practice, for the moment, no children are detained. The only thing is that now we have a new government for a few months now, and that unfortunately it's again the same very right-wing government we had in 2018. So yeah, we are not completely sure that it will not change again, but we hope it will. And I think that, yeah, the decision from the UNCRC is very important for that. So I'm sorry for the technical problems, but that's it for me.
Thank you. Thanks so much. And now, otherwise, we could see and follow everything. So thank you really for the excellent presentation. Also, yeah, I think for sharing the thinking of the lawyers behind considering which international mechanism to choose in a particular case. I think that's very interesting and could be often a question also that many of the participants here today may be asking themselves. And I would perhaps just add also from our side that ICJ also sometimes intervenes in the UNCRC cases with amicus curiae. We can perhaps also afterwards, together with the presentations, share 1 or 2 of our interventions. One of them definitely that also concerned immigration detention of a child. And perhaps if everybody agrees, we could still try to stay for 5 more minutes and at least open for some imminent questions or comments from the audience. If anybody would like to share anything or ask a quick question either to Mikiko or to Hind, you can just raise your hand and perhaps introduce yourself and yeah, make your comment or ask a question if you'd like. Yes, please go ahead. Kohanta.
Hi, hello everyone. I am in charge of advocacy for UNICEF in France, and I've got a question. Thank you very much for your complete presentation and for your work at the Committee on the Right of the Child. My question is about the binding effect of the CRC views and what we can do when once the final communications are adopted, the states still refuse to apply CRC recommendation and general measures adopted under the CRC third protocol. In France, following state refusal to apply the recommendation, following two decisions adopted by the CRC under the third protocol on unaccompanied minors, we've brought the case before the national highest administrative court, Conseil d'État, and the Conseil d'État recently considered that the convention does not confer a binding character on the views adopted by the Committee on the Rights of the Child under the third protocol. So this decision was adopted by the Conseil d'État on the 1st of July, and so I can share details on the chat. But yeah, we've got question on what we can do now, because that is the highest administrative court, and so yeah, Mikiko, maybe you have insight on what we can do.
Thank you for the highly relevant question. Mikiko, would you like to comment?
Yes, thank you very much for a very important question for all of us. And I would like to share some points which are discussed by the UN Human Rights Treaty bodies and also my own views. So this issue actually has been the issue for a long time of the discussion in the academia and also, you know, international lawyers and human rights lawyers. And so particularly for the, I think I just want to focus on this issue in the context of Europe, because in Europe you have a European Court of Human Rights, which is the real judicial body which can make a decision, legally binding judgments. So compared to that, I understand that the Committee on the Rights of the Child is not a judicial body. As I emphasized, it's not composed of the judges. It's not. It's very often the individual communication procedures are called quasi-judicial procedures, so which is not a real legal procedures. So perhaps the advocate and international human rights lawyers argue and want to argue that the views of the UN Human Rights Treaty bodies are legally binding. However, there is no, to my knowledge, there is no authoritative document which said that. Of course, there are similar. So, for example, Human Rights Committee in the general comment clarified the legal obligation of the state parties which ratified optional protocol optional protocol to ICCPR, saying that state parties to the optional protocol are obliged to respect, and I don't remember the exact wording. However, basically, you know, comply the decisions by the human rights treaty bodies under the individual communications. But it didn't. In my view, they also avoided very directly saying that views are legally binding, but rather focused on the state parties' obligations to follow or to respect the views. So now I want to come to my own view. I'm from Japan, and Japan has not ratified optional protocol yet, and there is always has been the discussion whether the views are legally binding or not. And so some of the lawyers and advocates in Japan have tried to argue this is legally binding. However, these days, the approach is not so much emphasizing the legally binding, because in any case, the treaty bodies are not the courts. However, more arguing that the treaty bodies are experts on that treaties, and the purpose of the individual communications to analyze and assess whether there is a violation or not. From the expert's point of view, which has the mandate to monitor and interpret. So the legally binding or not, we shouldn't just focus too much, but to argue that the state parties accepted the main convention, which created the treaty bodies, and give the treaty bodies the mandate to monitor, and how to monitor include country reviews and also individual communications. To accept individual communications, state parties need to specifically ratify the optional protocol. So this is the voluntary decision of the state parties to accept the authority of the treaty bodies to interpret from their expert as an expert of that treaties, as a human rights expert. So to make my point short and more and clearer, I myself I'm not so much concerned to argue the views are legally binding, but use the views as the expert findings about whether there is a violation or not. So, of course, it's different from the legally binding judgment, for example, such as the European Court of Human Rights. So knowing very well such difference, but still use this as a tool to convince the governments their obligations to respect and follow and implement the views of the treaty bodies. So I'm sorry it's not a short answer to your questions, but this is my own view. And beyond the discussion about the legal nature, how we should use the views of the treaty bodies trying to convince the governments and engage the governments in the dialogue is more important in my view.
Thank you. Thanks a lot, Mikiko. We should probably close in 1 minute, but I see one more hand. Just to say there's also some parallel discussion on this in the chat, so thank you so much for participating. And Martina, I'll give you the floor for kind of a last comment or question. Mm-hmm. Thank you.
Thank you very much. Hello to everybody. My name is Martina Tomina. I work at the Office of the Ombudsperson in Slovakia, and I actually would like to ask about the best practice to the not to detain children. We recently submitted an alternative report to the CRC, and we actually highlighted the issue of the detention, because in Slovakia we have a detention facility for migrants where also children with families are detained, and we recommended the government to change the practice, and also we highlighted this to the CRC. But I would like to discuss and ask what is the best practice in terms of really practice, how such a how the accommodation should look like for children with the families. I know that it has been a little bit discussed in the presentation in a theoretical terms, but I would be more interested in a practical way. Thank you very much.
Thank you. Mikiko, would you like to comment?
Yes, yes, I'd like to comment, and thank you so much, first of all, for the questions. And I want to be very honest and frank. Sorry for my ignorance, but I really don't know the best practices. So as you mentioned, the general comment provided the recommendations and guidance in a theoretical manner, or but in a general term, such as no detention and the community-based alternative, a non-custodial community-based alternative, and ask the state parties to invest the money not in the detention facilities, but into such community-based alternative. What does that mean? And so I am looking at you, Carolina. Perhaps the ICJ can collect the best practices, how it looks like if we are serious to implement the general comment. And so otherwise, so the committee said one thing, and whenever committee finds the state parties are not following strictly with the general comment, the then committee says that you have to change, but how and what it would look like. Actually, I think it's a very important, pertinent questions for all of us to show to the state parties. Yes, it is possible in this way and that way. So I really appreciate. I myself am a commissioner in ICJ, but we also need to look at the good practices. I agree. Thank you.
Yeah, thank you, Mikiko. I can just briefly add that we have done some years ago some work on this, in particular on alternatives to detention for migrant children. And we have actually really looked into alternatives that really would not include any coercive measures. And we have this set of training materials, which we can also actually share around, where we identified basically as the best practices that really as ICJ we would recommend, maybe not that are actually used as alternatives to detention by states. And these that we would recommend would be basically placing children in mainstream child protection systems when it comes to unaccompanied children. So really making sure that they would have actually the same access to the services as national children. That I think is kind of the main underlying kind of principle of these alternatives that we were recommending. And we can also share these training materials further with everyone. So I think we need to close. I'm sorry about that. We are running a little bit over the time. But thank you everyone for the discussions. Thank you also very much to our speakers for their time and for the insightful presentations. And as we said, we will keep in touch with all the participants of today with information on the upcoming webinars and other events and publications. We'll also share the presentations and other resources by email next week. And also we would like to ask you to fill in a small questionnaire that my colleague has posted in the chat. So thank you, everyone. Thanks a lot for your time and have a good rest of the day.